Hi, Ashley Ahrens, Client Services Director with the Rocky Mountain Victim Law Center, here for our fourth of 5 videos on the right to be present under the Victims' Rights Act. So if you've been following our videos now for a little bit of time, you'll notice a trend in some of what we're talking about, and it's that this foundational aspect we talked about 2 videos ago around the fairness, dignity, and respect comes up in many different ways, but is really the hallmark of what the VRA can mean to survivors. That we deserve to experience fairness, dignity, and respect throughout the process, which includes things like notification, as we discussed in the most recent video, but also today, where we talk a little bit about the right to be present. So what does that mean? So once a case moves forward and is going through the court process, so after an investigation has happened, after a case has been charged, there are now moments in a case's trajectory where someone can be present to understand what's happening in a case. That can look like, some of the most common times we hear this is around arraignments or preliminary hearings. We hear about this a lot during motions hearings or trial. Folks have the right to be present for those critical stages in an effort to ensure that they are understanding what's happening in a case that very directly relates to them. Our office talks about this as being a challenging point at times between a survivor's goals and hopes for an outcome, as well as a district attorney's hope to preserve a case. Our office, one of the biggest conversations that we have with survivors about the right to be present is how that can at times conflict with what's called sequestration. And so our office is able to have a balanced conversation with survivors about the pros and cons of being present for every single court hearing when that can impact potentially the outcome of the case. One of the biggest pieces that we think is a misconception here at our office is that individuals want to exercise all of their rights without any consideration to the impact it has on a case. When in fact, many of the victims and survivors we speak with talk a lot about wanting just to understand what their rights are, how it could impact the case, but never want to interact with those rights in a way that could inhibit the successful outcomes of a case, which really thankfully gets them on the same page as the district attorney's office and often allows for folks to find common ground during a time that can be somewhat conflictual. One of the other areas that we think is really important for folks to understand about the right to be present is during trial. So individuals who want to be present, for example, after they give testimony, often need to have an early conversation with the district attorney they're working with or with someone from our office, for example, to understand what needs to happen in order to make a successful situation arise where an individual could sit in on trial after they've already given testimony. We've seen DAs have victims go first in the lineup, or very early on in the lineup of a case, to ensure that there isn't a ton of information that's being shared prior to what they're saying, so they can get the fullest picture possible, but also so that someone could complete their sequestration in advance and then be able to come and sit down and watch the rest of the trial. One of the biggest things that we talk about with folks as they're going through that process is the right to be present doesn't entitle you to the right to act out in a space. It doesn't allow you to speak or disrupt the court in any way. There are, again, a lot of nuances to how someone might want to engage with the right to be present that could impact their case. So as with any other rights that you might have, if you have any questions about your right to be present in your case, whether that's pre-trial, at trial, or at trial, feel free to give us a call. We can talk through your rights and help you understand a little bit of what's possible for you, for your case, and to help you feel more engaged and participatory. The next video that we have will be our final video on the VRA, and it's going to be about the right to be heard, which is a very exciting right. It's the one that I think most people are familiar with in the form of victim impact statements, etc. So please tune back in 2 weeks to learn a little bit more about your right to be present. Thanks so much.